Hi, Lisa Figueroa here, board certified criminal defense attorney in Orlando. We talked earlier about the sentencing coming up on December 8th for Alicia Andrews' case. Well, her attorney just recently posted something online with a new update. Let's see what's going on.
So let me give you all an update on the Alicia Andrews case while I'm just driving in the middle of the Everglades right now. So that case was supposed to be set for sentencing December 8th. We filed a motion to have the judge disqualified from the case for bias during the trial. And the judge denied that motion, and so pretty much we're left in a position where we have to file an appeal to that judge's order denying the motion. That appeal is what's called a writ of prohibition. And because I was in the trial, the Megan Pete versus Milagro Cooper trial for the last 2 weeks and whatnot, I didn't have time to actually file that writ until yesterday, just yesterday. So I finished the other trial Monday, December 1st, and I filed the writ. Yes.
Okay, it looks like if you hadn't heard, they had originally filed a motion to disqualify the judge on the Friday, the last day of the trial before the sentencing. Now, what that means is a lot of times we hear about judges maybe being biased, and so you think, oh, well, you know, that judge should be removed. A lot of people don't realize that the way a judge gets removed is the attorney has to file a motion, and the person who makes the decision is actually that same judge. But the rules say that the attorney only has to allege certain facts, and the judge should not look at the merits of it. But apparently, regardless of what the attorney filed here, the judge denied it. And this was prior to the verdict. But now it looks like they are taking it up on appeal. You hear him say that he's filing a writ. Now, what that means is he filed a motion with the judge, and now you can appeal or ask the judge to, he wanted them to stay the proceedings, to go to the higher court. So the writ is basically a motion, a document that the attorney submits to the appellate court to get them to look over or review what the trial court did and to see if it's correct or not.
December 4th. The writ is like 17 pages long and it has a bunch of exhibits in the writ or attached to the writ. Those exhibits are videos that I cut up from YouTube, going through all the YouTube videos and finding examples of bias from the judge, or what at least I think is bias.
Now, what's really interesting and I think somewhat novel or new in this case is that typically when we move as an attorney to recuse a judge, it's usually because of the actions that occurred in the courtroom, things that were said, the impression that the defendant had based on whatever happened or commentary the judge made or rulings. And here, on top of those things, they're also adding YouTube comments and videos from just the public because this case was put online for everyone to see. And so they included videos, comments from chat, and all of that into their writ for the appeals court to rule on.
So because we're so close to the sentencing date, I need to push back the sentencing so that the appellate court has time to rule on this issue with the judge, and whether the judge should be presiding over the sentencing or any motions that are left to be dealt with in the Alicia Andrews case. So there's two ways that the court could stop the sentencing or continue it. One is I could ask the trial judge to push back the sentencing in light of the fact that I filed the writ of prohibition, or the appellate court can issue what's called a rule to show cause. If they issue a rule to show cause, then they will push back they'll actually stay the proceedings. It means they'll pause everything in the trial court until such time that they are able to deal with the appeal.
Okay, so basically they were scheduled for sentencing on December 8th, and her attorney feels that based on certain things that happened and everything that was alleged in his motion, that they had a valid basis to disqualify this judge, that the judge, for whatever reason, may not be fair or give Alicia Andrews a fair sentencing. And so typically this needs to be done in advance. That was done the Friday on the last day of trial, and that was denied. The attorney now can appeal that, and that's the writ that he's talking about. But in the meantime, the sentencing is still scheduled for Monday, December 8th. And so now what he has to do is to request that we continue the sentencing. Like, let's hold off and see if the court was right or wrong about denying the motion to disqualify her. So he had two options. One was to file with that same judge, hey, can we continue this? And he reached out to the prosecutor's office to see if they had any objection. And of course, they're going to object. And then he has the option to ask the judge, Judge, would you allow us to continue this and wait and see what the appeals court does? And if she says no, then his only other option is to go to the appellate court and ask them to issue a rule to show cause, or basically a writ to stay the proceedings. That means halt, stop the proceedings until a decision is made. So essentially he's trying to stop the sentencing from going forward, because the idea being that if this judge is the one that sentenced her, she's not going to get a fair trial based on the things that he laid out in his motion.
So I tried with the trial court first. I emailed the prosecutor yesterday, or maybe today, I can't remember which one, asking them if they would agree to, it was yesterday, asking them if they would agree to push back the sentencing. Of course, they said no. Once they said no, I reached out to the judge, filed a motion with the judge that was presiding over the case, but I had no faith that the judge would agree to push back the sentencing, and the judge denied the request to push back the sentencing. But at the same time, I was also working to have the appellate court stay the proceedings. So what we did was, and this is why it's important to know the rules of procedure, both appellate procedure and criminal procedure, wherever you're at, in whatever state, because there's a mechanism. If the appellate court issues a rule to show cause, then it stays the proceedings. It's an automatic thing. So I filed a motion for expedited issuance of a rule to show cause in the appellate court. And so while the trial court was trying to figure out what they were going to do on their end, I had the appellate court trying to figure out what they were going to do on their end. And I filed that. And today I was just calling the clerk at the appellate court, trying to get them to get the judges to make a decision. So around 3 o'clock, we get the denial from the trial court judge. She's denying the sentencing being pushed back. And then maybe an hour and a half later, we get an order from the appellate court issuing the rule to show cause and staying the proceedings, which means that we don't have sentencing Monday on Alicia Andrews. The judge that was supposed to sentence Alicia Andrews, at least for now, is not going to sentence her. She can't, if the appellate court agrees that with her decision to deny our motion to disqualify her, then she's going to get the sentence Alicia Andrews, but if not, then we might get a new judge to sentence Alicia Andrews.
So essentially, the appellate court did issue the rule to show cause and stayed the proceedings. That means the sentencing won't go forward on the 8th. And now they're going to wait to issue a ruling. Should the judge be disqualified and another judge assigned to handle the sentencing, or will they deem the motion insufficient to disqualify her? In which case, then the sentencing would go forward now with the judge that they just got through saying could not be fair, which is always a tricky situation for any attorney to navigate. But clearly, as a defense attorney, you have to do everything you can to protect the best interest of your client and make sure that it is a fair process and raise these issues so they can be dealt with even later on appeal after sentencing if need be. So I had a similar case where my client was charged with drug trafficking, and we did the trial. It's 2 counts, trafficking and then also possession of misdemeanor cannabis, and she was found guilty only of the misdemeanor cannabis possession. And the judge made a comment prior to sentencing being scheduled that why does she need more time? You know, she's a trafficker. And that comment led me to believe that he felt she was guilty even though the jury did not. And so I filed a motion to recuse him, and he denied it. And we filed a writ to the appellate court saying that there was sufficient basis to warrant removal of this judge and assigning another judge before sentencing. And unfortunately, the writ in that case was denied. So we were left to go back and face sentencing in front of the same judge that just got through calling her a drug trafficker after a not guilty verdict. And needless to say, unfortunately, even though it was just a misdemeanor charge that was left, he did impose jail time against her. And that's kind of one of the difficult things with the way the law is on this, that the fact that the judge that we're concerned with about being biased is the one who makes the decision whether or not to remove themselves from the case. Now, in my case, it wasn't a high profile or case that's being followed by the media where you have all eyes on the case. So this one's particularly interesting because we have it being broadcast. We have commentary basically from individuals who are independent and allegedly non-biased watching the actions and the rulings of the court, and the attorneys here are trying to use that to bolster or to give credence to their argument that this judge should be removed. So as of now, there won't be a sentencing on December 8th. We're going to have to wait to hear what the appellate court rules, and then we'll be back with an update and let you know before the new sentencing gets scheduled. Take care. Thanks for watching.